Namaskar to all the viewers across the country. I am Sanjula Halder, Deputy Director in the Directorate of Income Tax PRPNP at Mayur Bhavan, New Delhi. Welcome to another session from Samvad. As part of Samvad series, today we bring to you discussion on the topic Harmonization of Provisions Pertaining to Charitable Institutions and Trusts. For the discussion, we have with us today Shri Anurag Sahai, Principal Commissioner of Income Tax, Bengaluru. Shri Anurag Sahai belongs to the 1991 batch of the Indian Revenue Service and is presently working as Principal Commissioner of Income Tax Verification Unit, Bengaluru. Sir is an alumnus of Jawaharlal Nehru University, New Delhi and National Law School of India University, Bengaluru. Sir has also pursued public policy at the University of Washington, USA. Sir has worked within the department in Kolkata, Chennai, Mumbai and Bengaluru in various capacities, including specialized verticals of international taxation, exemptions and on deputation. Thank you, sir, for accepting our invitation for this episode of Samvad on the topic Harmonization of Provisions Pertaining to Charitable Institutions and Trusts.
Thank you very much, Sanjula. I'm very happy to be here.
Sir, firstly, I would like to ask you that it is well known that organizations that undertake charitable activities, they enjoy exemptions under the Income Tax Act 1961. So what are the charitable activities that are eligible for exemption and which are the organizations that can avail such exemption?
Thank you for inviting me to this session of Aikar Samvad. Namaskar to all the viewers. See, your question has two parts. The first is relating to the activities that can be entitled for exemptions, and the second is relating to the kind of organizations that can validly avail exemptions under the scheme of Income Tax Act. Let us try and understand both these issues sequentially. Number one is relating to the activities. Now, our law recognizes that exemptions can be granted for a charitable activity or a religious activity or a combination of both charitable and religious activities. The term charitable purpose has been defined in the Income Tax Act in section 215 of the Act, and our Act recognizes 7 kinds of charitable purposes, while 6 purposes are specifically mentioned, and they are relief to the poor, medical relief, education, preservation of forests, wildlife, environment, preservation of monuments, yoga, and the 7th purpose is what is known as advancement of any other object of general public utility, which is also, in short, we call it GPU object. Now, this GPU object is a residuary object. In order to have an activity which is charitable, this activity has to be for the benefit of general public. It cannot be for a benefit of a particular community or sect. Similarly, the second purpose is the religious purpose. A religious purpose again has to be a public religious purpose. As I have mentioned earlier, an organization can have a combination of both charitable as well as religious purposes, and these are the activities which can be claimed under the head of exemptions under the scheme of the Act. Now, coming to your second question about what are the kinds of organization which can avail exemptions. Now, basically you have to be incorporated either as a public trust or as a society or as a non-profit company. So, these are the 3 different kinds of incorporations which are allowable under the scheme of the Act. If you are a trust, you have to be either incorporated under the Indian Trust Act or under various public trust acts of states Several states in the country have public trust acts such as the Bombay Public Trust Act of 1950, the Gujarat Public Trust Act. So, incorporation as a trust is one option. The another option is incorporation under the Societies Registration Act as a society. And number 3, you have to be incorporated as a company, a non-profit company under Section 8 of the Companies Act 2013. So, these are the two basic requirements of having a public charitable or religious activity, that is number 1, and number 2, incorporation either as a trust or a company or a society in order to be able to apply for grant of exemptions under the Income Tax Act.
Thank you so much, sir. Sir, can you please explain to our viewers the kinds of options for exemptions available to the charitable institutions under the Income Tax Act 1961?
See, very broadly speaking, under the scheme of Income Tax Act, there are two options available for a taxpayer to avail exemptions. Now, exemptions, as the name suggests, means that your income is not subjected to tax. Now, these two options are number 1, what is known as approval under Section 1023C of the Act, and number 2, registration under Section 12AB of the Act. The approval under Section 1023C of the Act is also called the first regime of exemptions, and the registration under Section 12AB of the Act is called the second regime of exemptions. Let us try and understand these two regimes and what are the subtle differences between these two regimes. Under Section 1023C approvals, there is broadly two further subcategories. The first subcategory is of the entities which are either substantially or wholly financed by the government, or entities, private entities, whose total receipts aggregated under a single PAN is less than rupees 5 crores. Now, this subcategory of entities do not require any approval under Section 1023C of the Act to avail exemptions. The second subcategory under Section 1023C is of all entities which are engaged in public charitable activity or public religious activity or a combination of activities having gross receipts above the threshold of rupees 5 crores. Now, these organizations require approval under Section 1023C of the Act in order to avail exemptions. So, this is the first regime. The second regime of exemption is the regime called Section 12AB, and registration under Section 12AB is required for all taxpayers irrespective of their gross receipts. So, here the assessee desirous of availing exemptions under the second regime will have to apply for grant of registration as per the ordained procedure, and on grant of registration avail the exemptions. Apart from approvals and registration under 1023C and 12AB, we also have registration under Section 80G of the Act. Now, 80G is a very popular section, and I am sure all the viewers will empathize with that, because approval under Section 80G allows an entity to issue donation certificates to the individual donors, and these donors can avail deduction at a specified percentage subject to the qualifying limits under the Section 80G on their income. So, while approval under Section 80G allows a charitable entity to solicit funds, it also helps the individual donor in getting deduction of a specified percentage of their income in computation of their personal total income.
Thank you so much, sir. Sir, could you briefly tell us What is the registration procedure or approval for a new trust or non-profit company or society? And how much time does it take for the registration or approval to be granted? How to apply for the same, sir, and what documents are required to be filled for that?
I would be glad to answer that question. There are various questions you've asked regarding the process of registration. Let's unpack them one by one. The Finance Act 2020 introduced a novel concept of registration. In this novel concept, a new concept of provisional registration was introduced for the first time, and this is indeed a landmark tax reform which has been done by the Finance Act 2020. Let us try and understand what is this change. Now, under the new scheme, which was made operational from 1/4/2021, all existing entities were asked to reapply in the Form 10A and seek registration. In the earlier scheme of registration, once registration was granted, it was for perpetuity till such time it was expressly cancelled by the Income Tax Department. Under the new scheme, now registration is subject to renewal every 5 years. Once a registration is granted, assessee can validly avail exemptions subject to the conditions attached for availing exemptions, and after 5 years, the whole activity of the trust or the institution is reassessed and the registration is renewed for a further period of 5 years. In the concept of provisional registration, what happens is that a trust or an institution which has not availed exemptions earlier, or it's newly created, it's applying for the first time, it applies in again in the Form 10A. Now let me tell you, all these forms of applications are online. So the new trust applies in Form 10A, and immediately within the end of 1 month from the date of filing of the application, a provisional registration is granted to the taxpayer. One of the significant endeavor of the Income Tax Department has been to trust the taxpayer. So under the scheme of provisional registration, once an application is received, a provisional registration is granted to the entity without asking any questions. So there is no follow-up query by the department. The entire process is automated, the filing is online, and the provisional registration is granted within a very short time by the Centralized Processing Center, Bangalore. Now, once a provisional registration is received by the taxpayer, then that taxpayer is obliged to apply for registration or a regular registration either within 6 months from the date of commencement of activities by that trust or institution, or within 2.5 years from the grant of provisional registration. This provisional registration which is granted is valid for a period of 3 years. So therefore, if no activity has taken place, then after 2.5 years, this entity has to apply for regular registration. Once a regular registration is applied, and that application is made in Form 10AB. So initial registration was in Form 10A, the re-registration is in Form 10AB. Now this form is also online and it can be applied by the taxpayer from the comfort of its office, and once this application is received, then it is processed by the department. Now coming to your question on the kind of documentation which is required. Now as I told you, the process is online, so entire documents required have to be uploaded online, and for the convenience of the taxpayer, there is an extensive guidance note in the form which is published, and the taxpayer can look at that guidance and see that while applying for either provisional registration or regular registration, the basic details such as memorandum of association or objects of the trust or company, the KYC of directors, trustees or settlers, and the basic details regarding activities, the address, all that which is mentioned in the guidance note, these documents have to be uploaded, and once that is uploaded, as I mentioned earlier, provisional registration is granted very quickly. Under the earlier regime of section 12 AA of the Act, where the registration was granted directly, it used to take at least 6 months for grant of registration. Now the new entities desirous of availing exemptions under the Act can get registration in less than 30 to 45 days from the date of application.
Thank you so much, sir, for explaining that to our viewers. Sir, I would like to ask you one last question on the registration procedure. So you just mentioned that provisionally registered entities, they need to reapply for registration in Form 10AB, and the previously registered entities need to apply for renewal of registration, which is granted for 5 years. So could you please tell us what the department does on receipt of the Form 10AB application?
Viewers would like to note that while the grant of provisional registration is an automated process, the grant of regular registration is a verification process. So, this is the key difference between these two processes. The grant of registration is done by the Commissioner of Income Tax and not CPC. So, Commissioner of Income Tax exemptions, when he is granting registration or approval, he would undertake necessary verifications, he would verify the activities of the taxpayer, and he would also verify the compliance of any other law which is material to the grant of registration or approval. Here I must mention to the viewers that for the convenience of the taxpayers, this Form 10AB is a common form. So, whether you are applying for approval under section 1023C or registration under section 12AB of the Act or approval under section 80G of the Act, the form is common. The applicant has to select the relevant drop downs from the menu and file his application. On satisfaction of the Commissioner of Income Tax exemption, the registration or approval is granted for a further period of 5 years. However, if the Commissioner is not satisfied after undertaking necessary verifications, he may not grant registration, he may refuse the grant of registration by passing a necessary order in writing. Now, this approval process, for this approval process, a time of 6 months is given to the Commissioner of Income Tax exemptions, and this time is reckoned from the end of the month in which the application seeking regular registration is filed. So, this is in short the process of verification which is undertaken by the Commissioner of Income Tax before grant of regular registration. And as I mentioned earlier, this regular registration is to be applied once a charitable entity commences its activities. So, within 6 months of that or at the end of the 5 years of regular registration. So, in these two scenarios, application in Form 10AB has to be filed. Here I must mention to the viewers that the Finance Bill 2023 has further made a simplification of the process. Now, earlier what was happening was once a assessee would apply for provisional registration, and supposing it had already commenced its activities, immediately it would have to apply for regular registration. So, within no time it was forced to apply twice. Now, the Finance Bill 2023 has proposed that if the assessee has already commenced its activities prior to its first application of registration, that it can directly apply in Form 10AB for grant of regular registration, and that would be a verification process. So now provisional registration is to be applied for by the entity only if it is new and it has not commenced its activities. So this difference is being brought about by the Finance Bill 2023.
Thank you so much, sir. Sir, what are the various do's and don'ts that charitable institutions have to adhere to avail exemptions under the Income Tax Act 1961?
Yeah, there are various conditions which are attached to the grant of exemptions. Let us try and understand them. As I mentioned earlier, the two basic conditions are: one, incorporation as a trust, society, or a non-profit company, and second is the registration or approval either under the first regime or the second regime. Once these conditions are met, all income of the property held under the trust and voluntary contributions received by the entity, they are exempt subject to the application of 85% of that income for charitable purpose. So here the basic condition is that there has to be an application of 85% of the income of the trust earned during the year, received from various sources, towards the specified charitable purpose. Now, what is the specified purpose? The specified purpose is the purpose which is enumerated in the trust deed, in the object clause of the trust deed or memorandum of associations of a society or a non-profit company. So, those are the objects on which this income has to be expended, because the overall and the primary attempt of the government in granting exemptions to non-profit sector is to give a great fillip to philanthropic activities in the country and to take forward the public cause. So, the condition of 85% of the total income being expended during the year towards that charitable or religious purpose is a mandatory condition. However, there are further certain nuances which the viewers may note. Now, it is quite possible that a charitable entity is not able to expend 85% of its income during the year. Then what happens? Now, there are two options which the law gives to the assessees. Number one, a Form 9A can be filed by the taxpayers registered under the second regime. Please note, this is applicable only for the second regime, that is 12AB registrations. So, Form 9A can be filed specifying the income which has not been expended, and then that income can be carried forward to the following financial year, and it can be expended towards the specified charitable purpose. Now, in case of non-receipt of that specific income, the extension may go beyond that following financial year also, but from 9A is one option. The second option is filing of Form 10. Now, this Form 10 is also what is called an accumulation report in common parlance. Now, this accumulation report can be filed by the assessees both under the first regime as well as the second regime. Form 10 is filed specifying the amount which has not been expended and why it is being accumulated, because you see, application of 85% is the default law. Now, once an exception is carved, the reason for the same is to be specified in Form 10 as to what purpose has necessitated this accumulation of amount. So, that specific purpose has to be mentioned in Form 10, the amount has to be mentioned, and it has to be filed along with the due date of filing of return of income under section 139(1) of the Act. Now again I must mention here that both Form 9A and Form 10 can be filed by the taxpayers online. Once Form 10 has been filed within the due date with the specified purpose, the taxpayer can validly accumulate that amount and spend it in the next 5 years. So the Act allows the taxpayer liberty of carrying it forward for 5 years and spending it towards the specified purpose. Now here I must caution the viewers that specified purpose is very, very important. Once a purpose is specified, it has to be spent for that specific purpose only. If the taxpayer wants to change the purpose, then he has to apply before his jurisdictional assessing officer, specifying the change of purpose, and once that is permitted, he can undertake the changed purpose. Now this accumulation for 5 years, if it is not expended within that time of 5 years, then in the 6th year it becomes taxable. So this is the whole condition of application and accumulation which is there in the Act. Application of 85% by default mode. If it is not been applied, then Form 9A in the second regime and Form 10 for both regimes, and Form 10 will enable the assessees to carry it forward for next 5 years. Now here again I must mention the small change which Finance Bill 2023 has made. Finance Bill 2023 now has advanced the date of filing of Form 9A and Form 10, and that advanced date now is 2 months prior to the due date for filing of return of income under section 139(1) of the Act. The earlier and the standing present law is it coincides with the due date, but now once Finance Bill changes into Act after the passing by the Parliament and assent by the President, then the law would be that it has to be filed 2 months prior to the due date of filing of return under section 139(1) of the Act. I must mention here one more condition which the viewers must note. That is the filing of the audit report. The filing of audit report is of primary importance for the entities registered under the first regime or the second regime, because once an audit report is filed, only then the grant of exemptions becomes valid. Non-filing of audit report entails adverse consequences. Now this audit report has to be filed either in Form 10B or Form 10BB. Now it goes without saying that, like with everything in the income tax department, we have been trying to leverage technology for the convenience of our taxpayers. So again, this both Form 10B and Form 10BB are to be filed online. Now the new audit report formats have just been notified on 21st of February 2023. Now what has happened is that Form 10B is the common form for both the regimes, the first regime and the second regime. Prior to the notification of this format, assessees approved under the first regime used to file Form 10BB, and assessees registered under the second regime used to file Form 10B. Now Form 10B is the common format and it is applicable for all assessees with gross receipts above the threshold of rupees 5 crores, or it is having contribution from overseas sources, which means that it has got received foreign donations during the year, or it has expended amounts outside India for the charitable activity during the previous year. So if any of these conditions are met, that is the threshold of 5 crores or spending amounts abroad or receiving foreign donations, if either of these three conditions are met, then the specified audit report is Form 10B. Form 10BB is a much simpler report and which is applicable for entities with gross receipts less than 5 crores, not receiving foreign donations and not applying anything abroad. Now, this Form 10BB is a very simple report and would convenience a large majority of charitable entities in our country. But the due date of filing of these audit reports either under Form 10B or 10BB is 1 month prior to the due date of filing of return under section 139(1) of the Act. So, the primary conditions which I would like to flag again for the benefit of the viewers is the rules of application, the benefit of accumulation by filing Form 9A or Form 10 and the mandatory filing of specified audit report either in Form 10B or Form 10BB as applicable. So, these are in my view the basic nuances and the do's and don'ts.
Thank you so much, sir, for patiently explaining the do's and don'ts for charitable institutions to our viewers. Sir, I'd like to ask you that you just mentioned that non-filing of the prescribed audit report in Form 10B or Form 10BB or the accumulation report in Form 9A or Form 10 invites adverse consequences in terms of denial of exemptions to the charitable institutions. So, due to COVID 19, we know that many charitable institutions could not comply within time with this. So, is there any way out for these institutions?
I am so glad that you asked this question. The COVID-19 pandemic was one of the reasons where a lot of charitable entities were not able to file either accumulation report in Form 9A or Form 10 or the audit report. And indeed, there can be certain unavoidable reasons where there has been delay in compliance. Now, in order to take care of such exigencies, the Central Board of Direct Taxes has issued notification under section 119 of the Act empowering authorities to consider the condonation petitions filed by the taxpayers seeking condonation of delay in filing of either the accumulation report or the audit report and then decide accordingly. On a favorable decision by the specified authority, the jurisdictional assessing officer will undertake necessary rectification and the exemption or the accumulation which has been denied by the CPC for delay in compliance. Now, that amount is nullified and relief is granted to the taxpayer. Now, here I must mention that any delay up to 365 days is within the domain competence of Commissioner or Principal Commissioner of Income Tax. Any delay which is between 1 year and 3 years, the assessees can apply before the Chief Commissioner of Income Tax or Principal Chief Commissioner of Income Tax. And any delay in filing audit report or accumulation report beyond 3 years, the taxpayers have to directly approach Central Board of Direct Taxes, and CBDT also in its direction to subordinate authorities has directed all of us that such condonation petitions have to be disposed within 3 months of the date of filing by the taxpayer. So, there is a way out if in case of genuine reasons where the delay has happened either because of pandemic or any other justifiable genuine reason, relief is granted to the taxpayer based on the necessary orders by the specified authorities.
With this, we come to the end of today's session on harmonization of provisions related to charitable institutions and trusts. I thank you all for joining us for this episode. Do follow us on our social media handles on Facebook, Instagram, LinkedIn, YouTube, and Twitter, and keep watching for updates on more educational and informative content. Until the next time from Samvad, thank you and Jai Hind.